Thanks to both speakers. This question is for John, but Tom, you might have something to say about it as well. By chance, I attended a seminar yesterday in the Department of History here by Colin Reid about the rhetoric used in the defence trials of the 1848 rebels. And the paper pointed out that one feature of Irish legal rhetoric and Irish legal culture in the 19th century was frequent appeals to what you might call a political right, that in defending rebels, lawyers like Butt and Whitehouse, they made what he called Lockean claims concerning the natural rights of the Irish people, and frequently referred to the political wrongs of the Act of Union and the injustices of the Act of Union as a part of legal argument. And so what he said distinguished the Irish from the English bar in part was a particular rhetorical style which integrated political right within legal argument. And I suppose that idea of legal and political right as being contiguous or integrated was by then anachronistic in British legal thinking, and that's what made it quite unusual or distinctive or exotic to some English onlookers in the context of the 19th century. But to what extent was the thinking of 1916 in legal terms, in terms of legal justifiability, in what sense was it continuous with that tradition of integrating political right within legal thought? In other words, when the rebels and when the intellectuals of that period appealed to concepts like the rights of a nation that was inextinguishable, did they understand that as an extra legal claim in that revolutionary sense, or did they understand that as a claim of political right that could be articulated in legal rhetoric and in a legal mode?
No, well, you're correct to identify that tradition, and O'Connell himself, of course, was the paramount exemplar of that, because he made the argument that the Act of Union was invalid because of the lack of authority of the Irish Parliament to surrender its own powers held in trust for the Irish people. And Isaac Butt would be a very good example too of how the parliamentary and advanced nationalist rhetorics ran in parallel. There could be a connection there, but I think it's very hard to find evidence that the leaders of the Rising were actually conscious of these continuities or drew upon them to any great extent. I think it's pretty clear that they were influenced by continental nationalist thought, that there's another layer is certainly laid over. So there's a limited continuity. I mean, if you push it back even further, the claim has been made that a lot of this is it's the residuum of a departed Jacobitism to some extent, that this idea of legitimacy is first planted by the idea of the repudiation of the parliamentary monarchy that's created in Britain at the beginning of the 18th century or the end of the 17th century. And that really once you're deprived of your lawful Stuart monarch, this idea of an alternative claim to legitimacy that supersedes that of state institutions, that's actually a surprising, original historical antecedent to this. But no, it's certainly part of the same tradition, and it comes to the fore. But of course, one of the things the 1916 leaders, apart from Casement, were deprived of was the opportunity to make that kind of speech to the dock. I mean, Pearse does in a very abbreviated form, but to obviously not a very sympathetic audience, and without, any guarantee that it will become public or certainty that it will become public at any stage. So I think that's in the background. It would have been part of their general culture, but I think it would be very hard to say that they saw themselves as acting in a way that advanced that claim in some kind of, I mean, they were asserting Ireland's entitlement to freedom, but I'm not sure that they were particularly influenced by the way in which that had affected Irish legal culture in the previous 150 years.
The only thing I would have to add is that whatever of the leaders of the 1916 Rising, you certainly see evidence of this tradition in the works of Arthur Griffith. In his Resurrection of Hungary, there's extensive legal analysis of the Act of Union and its invalidity and so forth.
But I mean, the leaders of the Rising generally many of them regarded Griffith as an odious pedant who was kind of wrecking the Irish nationalist movement through his, his cranky kind of Puritanism and these strange ideas of, Hungarian freedom for a lot of them, were really a reason for treating him as a curiosity rather than a serious political influence. Josh?
If I could just abuse the privilege of having, feel a bit like the Archbishop of Cashel having thrown the ball in and then suddenly participating in the hurling final. I'd love to hear the observations of both contributors, who both provided wonderfully stimulating papers about two somewhat separate things. The first is something I came across recently, which was the Marits Rebellion in 1914 in South Africa, which declared a provisional government to be free for all, of course, white South Africans. But the reaction to that was interesting, because Smuts's reaction was, rather than execution as took place with Maxwell Asquith in 1916, the rebels were imprisoned or fined for a relatively short period of time and thereafter released. In other words, it was a conciliation model rather than a coercion model. So I think when we look at Maxwell, it wasn't as if the only model that was available to him was coercion, because quite recently, only 2 years before, there had been a rebellion which had been dealt with in a very different fashion. It's something I didn't know about until I came across it recently. I'm sure you guys do. The second point is in relation to Tom's point on what-ifery, the extent to which the Statute of Westminster was actually driven by Irish considerations, Irish Free State considerations, I think is interesting. And it was something that Stanley Baldwin complained about during the debate. And he said we mustn't always be thinking of the Irish Free State. So I suspect, the precipitating factor to the Statute of Westminster, which in turn created room for Dev to introduce a whole series of legislative measures in the 1930s, which created the impetus for, and without the Irish Free State impetus, that is the independence movement and the War of Independence, it might never have happened at all. Question?
I would just say about the Statute of Westminster, yes, I agree with what you're saying. In fact, in New Zealand, there was a tendency to refer to the Statute of Westminster as the Statute of Dublin. It was perceived as being that influenced by Irish factors. Billy Hughes, the Prime Minister of Australia, complained that in enacting the statute, they'd listened to newcomers to the Table of Empire, a very obvious reference to the Irish. Yeah. But it's not so, I mean, when you look at the parliamentary debates as well, it's all about Ireland, hence Baldwin's frustration that this major bit of legislation in Commonwealth and imperial history, and it was turning into another kind of Home Rule Act debate, maybe the last of them, you could argue. But what's interesting as well from a legal point of view is that the statute, at least in theory, only applied in full to the Irish Free State in 1931. So there were good reasons for this Irish focus, you know, but it is, in my opinion, something that's very much underrated in Irish history, the importance of the Statute of Westminster. The Canadians actually celebrate it as they mark it at least as a federal occasion, whereas in this country, where we probably owe as much to it as any of the others, it's ignored, even brushed aside occasionally in some of the older court judgments.
Although, of course, ironically, the Canadians didn't get around to patriating their constitution until 1982, so they were still relying on Westminster to make amendments to it. The point about the Marais Rebellion and other similar incidents is very interesting, because there was, at a conference in UCD a number of weeks ago, a South African speaker was tracing exactly how Sir Matthew Nathan was a very important personal connection there, because he had dealt with a rebellion in the Gold Coast, in Natal as well, I think, and there have been various difficulties in Hong Kong, and obviously he was sidelined in the aftermath of the Rising. He was, you know, a cipher, really. So it would have been interesting to see if there'd been a civilian Irish executive response, whether Nathan's... I think one of the suggestions in the paper was that Nathan was disillusioned, really, by the way in which his inclinations towards leniency in some of these situations had been set aside in favor of gratifying the desire for vengeance of the local settler politicians in Natal, for instance. So Nathan wanted to make certain, you know, give certain guarantees to the native population, but the secular political leaders just, brushed him aside. So there's some suggestion that in 1916 he was somewhat disillusioned by some aspects of this experience, and this may have contributed to his passivity in the Irish situation, that, he just, because, for example, the leaders in Natal complained that he was a Freemason, I think, probably quite groundlessly to London, but there was a lot, because of his Jewishness as well, there was a lot of hostility towards him in some quarters, so this may have sort of closed down his psychological sense of what he could do in the Irish situation, and have explained some of the strange passivity he showed in the months leading up to the Rising.
Any other questions? Mary?
Just an observation perhaps is that I found both papers very, very interesting. But of course one of the key problems at the time was actually the Ulster Unionist issue as regards whether Dominion status would have been acceptable. Well, in fact, Home Rule might even have been acceptable if it was for an all-Ireland situation. And of course there are arguments on the Unionist side about their own rights as well. So do you have any thoughts on the Ulster question? Or?
Well, that's the big issue, of course, whether any branch of Irish nationalism in 1916 really had come seriously to grips with the problem of Ulster, whether any of them had a... You could argue that the parliamentary party, Redmond in particular, thought through that problem more seriously. Clearly, the leaders of the Rising had a rather... Well, their focus was different, but I mean, it did result in them having a rather superficial appreciation of the problem, the obstacle that Ulster presented. I mean, it is interesting that given the nature of the Stormont settlement being, a miniature version of what was proposed in 1920, certainly, that there was talk in the 1930s and 1940s of Dominion status for Ulster, of course. There was quite a strong current of opinion in Northern Ireland that the Home Rule settlement, as it applied to Ulster, was really unworkable, and that the purpose of it had been to protect the Ulster Unionist community from Dublin, but that really it might make more sense to turn Ulster into a Dominion rather than continue with. Now, that was, there were obvious flaws in that kind of argument, but it was certainly a minority current within unionism about the instability of Home Rule as a solution, that it couldn't really, in the same way as arises in Scotland as to whether devolution is a stable, settlement, or is it just a transition to, inevitable independence in one form or another.
Well, that was certainly the case in Ireland, I think, because Pearse would have been happy with Home Rule as a first step, but he believed that within 10 years there would be a revolution.
Yes, indeed, and Hobson and others wanted to see a national militia as the, nucleus of a national army.
System, yeah.
Although, of course, it's often forgotten that at least in some sense, Redmond saw the Irish participation in the British Army in the First World War as the core of an Irish army of some kind of the future, so that by proving loyalty, by proving, commitment to the empire, Ireland would eventually be accorded its own. The veterans of these campaigns would eventually form the core of an Irish military of some kind.
I just, say that yes, the Ulster question was central to the granting of Dominion status. De Valera's tactics was always to link the issues. In other words, it was either Dominion status for the entire island or total sovereignty for the 26 counties. Now, of course, the tactic of breaking on Ulster didn't work. Historians have talked about that at some length. I would add to what John has said that actually it wasn't just in the 30s and 40s that there was a movement in Northern Ireland for a separate dominion. Actually, during the time of the treaty negotiations, a serious move was made, rebuffed, interestingly, by the British government by saying, no, Dominion status is for nations. You're a fragment of a nation.
In relation to Tom's point about distance, of course, during the Irish Convention, one of the Irish Unionist arguments against Dominion status was that Dominion status was imposed, let's say, on the New Zealanders by distance. If the New Zealanders were as close to the mother country as the Irish were, obviously they would elect to be represented in the Imperial Parliament. It was just because they were on the other side of the world that they were forced to be free, really.
Okay. So thank you both very much, and thank you all for coming and for your very interesting questions. We're going to break now for lunch, and we'll be back at, was it 1:30 or 2? 1:30. Okay, thank you.